Non-judicial foreclosure is one of the most misunderstood systems in our country. Most homeowners think that if there's no lawsuit, the bank must have already proven their case. That's false. Non-judicial foreclosure moves on assumptions unless somebody forces proof. That somebody needs to be you in that situation. Don't wait until it's too late. I can't tell you how many clients in non-judicial states come to us when they're at the final moment of being evicted, when it's very difficult to overturn these cases. You need to act early. So here's what you need to do. You need to force proof. Today we're going to be talking about non-judicial foreclosure with a certain focus on California, Georgia, and Texas. And we're going to teach you how to fight back strategically. We detail this in greater detail in a blog post. You can find that link in the comments. First, what does non-judicial foreclosure really mean? In judicial foreclosure states, the lender usually files a lawsuit first. In non-judicial states, the process begins with notices and trustee procedures. That includes notice of default, notices of sale, assignments, and trustee documents. The system is designed to move quickly, but speed is not proof. Here's the biggest mistake most homeowners make, and I think I alluded to this just a second ago. Homeowners are just waiting too long to act. They assume they can fix everything after the sale. Sometimes they can, most times they cannot. The leverage is strongest before the trustee sale occurs. That's why timing matters so much. For example, in California foreclosures move very quickly. Homeowners should immediately analyze substitutions of trustee, assignments, servicer authority, and timing issues. Many documents appear years after the alleged transfers, and that matters. The sequence of these signatures, oftentimes by robo-signers, are critical. You need to understand that, need to analyze that. Let's talk about the state of Georgia, a very difficult state for us in foreclosure defense. It's one of the fastest foreclosure states in the country. Very little court involvement happens because homeowners, unless the homeowner forces the issue into court. That means homeowners must act early and analyze notice of compliance, authority claims, and chain of title problems. And lastly, let's talk about Texas a bit. Texas also moves quickly, but homeowners still have options. That often includes temporary restraining orders or TROs, injunctions, and wrongful foreclosure claims in the form of independent actions. The key is forcing proof before the sale happens. So what actually wins cases? Let me share with you our experience on how we've won cases in non-judicial states. We don't win with emotional arguments. The courts disregard those. We don't use conspiracy theories. We don't use arguments like sovereign citizen arguments that just don't work in court. The strongest defenses focus on legal standing, authority, chain of title, timing, and evidence. That's how foreclosure defense works. Non-judicial foreclosure does not mean the foreclosure is automatically valid. It means the system moves forward unless somebody challenges it. Force proof. That's where cases change. Ask us how and learn more at the full detail on our latest blog post in the comments. There's a link in the comments there. And call us. If you need help analyzing your case, you can reach us toll-free at 866-216-4126 or at defendtheforeclosure.com or livinglies.me. And remember, your home is your castle. We help you defend it.